We are live and on the record.
Thank you. Good afternoon and welcome to the Appeals Court Oral Argument Session for October 4th, 2020. This is our last case of the day. We've heard 5 of them in person, but we've allowed the parties' motion to hear this one on Zoom. The case is 2020 P1263, Brosnan v. Brosnan. As usual, as we do it in the appeals court, each side gets 15 minutes. There's no rebuttal. When you're not arguing, we're going to ask you to put yourself on mute, but still stay on the screen so we can still see you. But at the same time, realize we can see you, so try to keep your reactions to a minimum. The case, as you know, we're doing this on Zoom. It's being simultaneously streamed on YouTube. Your panel for today is me. I'm Greg Massing with Justice James Lemire and Justice Catherine Hand. And we've already called the case, so we'll hear from the appellant, which is, I believe, Attorney Cathawala.
Yes, Judge. Good morning, Your Honors. Penelope Cathawala for Richard Brosnan, the appellant. Judge, this is an appeal out of the Hampden County Probate Court with respect to 2 issues that we have briefed today. Number 1 is the abuse of discretion in 2 fronts. One, by the trial judge when she went beyond the durational limits, went over and above the durational limits of the parties, and when she further went above and beyond the full retirement age of the appellant when he reached his full retirement age in 2018. So we're asserting, Judge, that these 2 aspects of going beyond both those limits were an abuse of her discretion. We assert this and allege this because although the wife has had since the parties were married a what's called a chronic illness, I believe a connective tissue type of illness, which allows her joints from time to time to go out of the socket, that by her own testimony at the trial, she said she would, and the medical report that was submitted at the trial, she's been doing very well. She's independent. She doesn't really need any assistance at home. She doesn't use a walker, cane, or crutches when leaving her home. She's made very good gains in her strength, endurance, and balance and functional mobility in all spheres, and is enjoying an increased quality of life, not decreased, and even has a serious boyfriend with whom she testified she has had intimate relations. And again, those are all cited in my brief as to the particular transcript dates and pages. Again, we're asserting that although she's chronically ill, and she is now 68, she was 67 at the time of the trial, or 66 and a half, that she could do something by way of a little bit of supporting herself if she needed some kind of additional revenues or income. I would also draw to your Honor's attention the fact that she still maintained 1/3 ownership in the marital home, 2/3 of which she had conveyed to her daughter and her son-in-law, asserting at the trial that it wasn't a gift of $174,000 or $175,000 in equity, but it was some sort of sweat labor that her son-in-law had incurred, adding on an in-law apartment to her marital home. But nonetheless, even so, there was over $230,000 left in equity in the property that she could have utilized. I'm sure you noted in the findings that the former Mrs. Brosnan's income was such that if she got $200 or more, she would be not qualified for that PACE program that she enjoyed attending. Moving on so for those reasons, I'm suggesting that although the judge made some findings, I'm suggesting they were really an abuse of her discretion.
Ms. Cathawala, are
sorry.
you suggesting any of the judge's findings are incorrect?
Yes, I am, Judge, and that's the second phase of.
All right, but on her disability aspect, are you suggesting there are any of the findings that support the judge's decision that she's entitled to the durational portion because of her disability? Are you suggesting any of those findings are incorrect, or you're just saying your interpretation is different than the judge's?
Well, I am saying that the findings that she made with respect to the amount of the spousal support that would be paid by my client to her.
I'm really focused on the medical side.
Oh, okay. Then I am suggesting that from the medical records and the current record that I did cite, she is doing well. She's fine. She attends the PACE program. I mean, this particular illness she has, she had before they were married. So this isn't, and the medical records, I would say currently, the ones that were submitted by the appellant suggest she's doing very well. She's very independent. She doesn't need any help. She doesn't need a walker. She doesn't have crutches. So and she has great functional mobility in all spheres. And I'm suggesting that that this money that was awarded to her was just sufficient enough to keep her within the PACE program, but not disqualify her. Secondly, I'm saying that she really dissipated an asset. Oh,
Justice
sorry.
Lemire asked you if the judge was clearly erroneous in her findings with respect to the disability, and I say that she was wrong about the money. But
I'm saying she was wrong about, well, of course, she's alleging and asserts and made a finding that she was disabled. And I'm suggesting to you, she has had that chronic illness since prior to the party's marriage. I think actually she was born with it, but I don't want to misstate that information. But I do know that at the time of the marriage, that she had that same chronic illness, and it doesn't, and the latest medicals that we had submitted said she was doing well. She had functional mobility. She left the home. She could walk. She had no walker, no assistance. So I'm suggesting that, disability is a broad term. She has a disability, but does it keep her from does it keep her from babysitting? I'd suggest no. Remember that the people who purchased her home, allegedly, she never received any money for this home. She deeded them 2/3 of her house, that is her daughter and her son-in-law.
Was the home a marital asset?
It was. She received the home in the divorce, which was in 1994.
Okay, if that was an asset she got in the divorce, then how can the judge count it as income?
I was not, because she allegedly sold that to, it's just income for purposes of supporting her lifestyle. She allegedly sold it, I'm suggesting allegedly sold it, to her daughter and son-in-law, who had lived there since 2012. I might add.
The testimony, though, that money that she received for the house was to recoup the cost of building out an accessible location for her, which is probably not a major point in the case, but not really income, but compensation for an adjustment to the house.
Well, that was the testimony at the trial that she put forward. She deeded 2/3 and kept 1/3, which she still maintains today. And it is held as joint tenants with the right of survivorship, so that when she dies, her daughter and son-in-law get the balance of her home. And it did have, and you'll see in the transcript, substantial remaining equity. And moving on to what I suggest is the second abuse of discretion is simply that the judge made some incorrect calculations. She assumed that the former Mrs. Brosnan was receiving 1/2 of Mr. Brosnan's Social Security benefit, which was not the case. It's clear, by the way, in the transcript, and I do cite that it's at page 129, just to highlight it. She testified that she has her own Social Security and they take some of his and add it on. That is in the transcript. The trial judge, for whatever reason, decided at finding at her in the record appendix, page 33, finding number 27, she seems to think that the appellant made a mistake in calculating what his Social Security benefit was and is. That's not the case. His Social Security statement was introduced at the trial, and his calculations of his monthly benefit were also on his financial statement. The judge.
Can I ask you about that? We have that exhibit that says he received 27,000 some odd in 2018 from Social Security, which divides out to $527 a month. So, and we also have the evidence in the record that he reached full Social Security retirement age in October of 2018. I gather that the fact that he received 27,000 in the year that he reached retirement age, that he must have started receiving before his full retirement age, in which case he'd get a reduced amount. Do we have any evidence in the record when he started receiving Social Security?
I believe he started receiving it when he reached full security age, but I'm not sure that was in the record, Judge.
Well, no, that can't be true because unless he would get a whole year's worth. No, that can't be true, because he got 27,000 in a year where he reached that age, and he only reached that age 3/4 of the way through the year.
Okay. Well, the trial was in 2019.
Right.
So I
think the answer to there's no evidence on the record when he started receiving it.
That's correct, Judge. There is none. There was none. But the judge, for whatever
in his testimony, in your client's testimony, he made a comment about it was his understanding she would receive half of his Social Security. And it tied in if he was collecting at, full amounts at the full, whatever the terminology is, but the latest retirement age in which he'd get the full amount. So he did make a comment about her getting half. And then the wife said she was receiving $309 a week. So, I mean, there is a basis in the transcript for the judge's determination, because your client indicated it was his understanding his wife would receive half of what he would get at full retirement age, and that she was getting $309. So the judge credited him for $618.
Well, then did she discredit Mrs., who on page 129 of the transcript says they take my Social Security and some of his and add it on?
Well, I don't think they're inconsistent. In other words, she would get something more than what she was entitled to because of his Social Security, and it was his understanding it would come out as half, not necessarily taking from him, but calculated at half of his benefits toward her. The question is, how do we make the decision? Because the exhibit shows, as Judge Massing pointed out, him getting 527 or some number like that dollars a week based on his gross payment, and the judge's determination that he would be getting $618 based on his testimony. There's the rub, and what do we do with it?
Well, I think perhaps it has to be remanded back, which is what I had suggested. And I would further say just at the end that the judge in her finding and rationale said, it's just fair that we give, I'm using the party's Social Security information and what they receive. And and basically it's only fair that she gets $150 a week. And I do cite the exact place where that is.
Doesn't that feed into Mr. Moriarty's point that he makes at the very end of his brief, was that even if the judge erred the calculation of the respective Social Security payment. Her idea was that $150 was about fair. And she could have, if we remanded it, couldn't she come up with some other rationale for saying, his expenses seem to be rising, but I don't credit that they rose. It's still the same as it was in 2015, and I'll give him a little bit of credit, and 150 seems about right to me.
Well, that's what she said. Seems right to me.
No, but is
I
it
don't
an
know.
abuse
Then
of
I go back to,
does it mean it's an abuse of discretion though?
well, again, I note that it's about $50 less than what would knock her out of the PACE program. So I'm sure the judge considered that, because that's also in the findings, that she could make no more than $200 a week. But I go back to this gentleman, the durational limits were reached in 2011. That's when he could have applied and filed a modification to terminate the alimony. He waited until November 2018, which was his full retirement age. So he went beyond, I'm just suggesting, 2 durational limits. First of all, the length of the marriage, which should have at least given rise to a modification. He waited and went to his, because he was continuing to work, waited till his full retirement age. Although he retired when he was 64, he continued to pay till he was 66.
Okay, well, thank you very much. I think we got it. Any other questions? Okay, no. So we'll hear from attorney for Susan.
Yes, my name is John Moriarty. I'm from Holyoke, Massachusetts, and I represent Susan Brosnan in this appeal. First of all, I would like to point out that the disease that my sister has been talking about is called Ehlers-Danlos Syndrome. It's particularly insidious in the way that it operates, attacking the joints, so that just about all the joints in her, major joints in her body, are subject to slipping out and dislocating, causing her to fall. And in fact, going back in time to 2012, that was the reason why she had to leave her part-time employment as a receptionist at the Chicopee Medical Center, because she was continually falling at work and it was too dangerous. She was also having some mental acuity problems with numbers, and that was part of her duties at that job. So she found herself without her part-time employment, and without that, she wasn't able to make the mortgage payment on her house. And so that was when she decided it would be a good idea to see if I could have my daughter and her son-in-law move in with me and let them, live in my house and share the burden. And the plan was made at that point that instead of her pursuing going to subsidized housing or elder care housing, that they would try to form basically what the judge determined was a form of assisted living, basically by their own stamp, rather than putting her in a facility like a nursing home or an assisted living facility that wouldn't be as conducive to quality of life. So what they did was they refinanced the house, and at that point, the son-in-law, through his own labor and effort, not only put on the addition in which she now lives and has lived since 2000 and at least 13, I think, or 14, but also completely renovated the existing home. So it wasn't just putting on the addition, it was substantially more than that. And so she was able to stay at home. And eventually she was able to apply and get accepted at the PACE program, which is what is called a program for all-inclusive care for the elderly. That's where PACE, where the moniker comes from. And quite to the contrary, as asserted by Attorney Kayawatha, The PACE program gives her substantial benefits, including transporting her. She doesn't drive. She can't drive. Transports her down to their facility where she has some social interaction and gets physical therapy. Also, they have a person that comes in. She writes them a blank check to the grocery store, and then she goes off and does the food shopping for her, which she can't do. And they also have a person that comes in and cleans for her so that she can function normally. She does, again, contrary to my sister's representation on this, have durable equipment that she has to use today, and which is even referenced in the portion of the medical records, which I think she relies on. She has what is called a Loft-Strand crutch, which she uses not just in the home, but outside the home as well. Yes, she has a boyfriend. I'm not going to dwell on that, and I leave it to your imagination as to how people can become intimate. But the point is that she's able to do that without apparently dislocating her hips or in ways that doesn't happen. Her principal problem is with her knees and her hips. In the medical note that my sister was talking about from 2019 in November, she reported that she was suffering pain from the subluxation and dislocation in falls at a level, a basic level of 7 out of 10. There was also material in there that indicated that she was having problems with her left hip, burning pain that wakes her up, or on walking, or on doing what she called idiot things. And I interpreted that to mean something that was beyond what she was capable of doing. She testified at trial that her hip regularly slips out of whack when she's in bed. There in the note from November of 2019, there's indications about how she had to lower her bed in order to make it easier for her to make compensatory movements to avoid having the joints slip out while she's sleeping and so forth. So this is a particularly horrible disease. There is a medical.
Are you saying that the judge wasn't clearly erroneous to find that this disease and disability prevents her from meeting her basic needs without financial support?
Yes, I am saying that. But first of all, with regard to 53E1, a chronic illness that prevents her from working, there was a medical report in the record from a Tazim Alim, which you will see, who's a treating physician, where he makes the point that it's an incurable disease that she's had since childhood, and it renders her disabled from any gainful employment. So yes, I would say that there's not just a small amount of evidence in the record that would support the judge's finding, but plethora. So on that point, I mean, I could go on. It takes her 2 hours, you know.
Yeah, I don't think you need to go on. Can I ask you about the Social Security payment?
Yes.
The parties actually stipulated that the husband's Social Security benefit was $527 per month. Isn't that right?
I don't remember a stipulation on that. If there was, then I can't argue against it.
There's one on the record. It's a stipulation.
I assume that you would say that. Yes.
Yeah. So I mean, so was the judge then clearly erroneous to say that his monthly payment was $618 when there's a stipulation that is $527?
Well, I'm not sure that the judge can't make her own decision on that, regardless of the stipulation of the parties.
So stipulation is just one piece of evidence that the judge can consider.
Yes, that's what I would indicate. And there was testimony from the husband himself that, if I could find the quote, He says, what was it? They were asked about his understanding with regard to that. And as he said, my understanding is that she is now collecting half of my full retirement Social Security benefits. I had the same question with regard to the amount of the benefits from 2018 being what they were, and because there's no evidence in the record as to what they were in 2019 when the trial occurred. The only evidence is what his testimony was and what hers was, which, as the judge pointed out.
If I could interrupt, Mr. Moriarty.
Yes, sir.
It's my understanding if you start collecting Social Security prior to the maximum age, which is like, say, 70,
Yes.
you get less. So if you start collecting at age 66, you wouldn't get as much as you would at age 70. And is
That's
that
true.
what they're talking about when they're saying at his full amount?
Yes, I think his amount could be different in 2019.
So if, but if somebody started at age 66 collecting Social Security, when they reached 70, it wouldn't go up, other than maybe cost of living. It wouldn't jump to the full amount. You've chosen to take a less amount for more years by starting at age 66. So, I mean, maybe his full amount would have been 618 if he had started collecting at age 70, and maybe that's what she is entitled to get half of his full amount. But it's clear, or it seems clear from the exhibits and the stipulation, that although she might be collecting what he would have gotten at age 70, he's only getting 517. And I mean, do you agree that the evidence is indicative of that? And is that a clear error? And if it is, do we have to remand?
No, I don't think you have to remand, because I believe that there were other findings that the judge made with regard to his income versus, his liabilities, and comparing them from 2015 and 2019, showing what she indicated was an unexplained tremendous jump of 72% in terms of his living expenses. So I think her decision could be justified on the basis of that set of facts, where, for example, his debt service, let's call it, for the sake of argument, because I don't have the exact numbers in front of me, $48,000, in credit card debt. Well, that was the same in both years, in 2015 and 2019. Yet he was paying somewhere around $100 or $109 per week towards that debt back in 2015. By the time we get to 2019, it has now jumped to over $300 per week. In other words, she made, and I think the judge made a finding on this point, that there was an increase in what he was paying on the debt service. And what she indicated was an unexplained rise in the expenses that weren't covered. And I went over.
But wasn't her decision on the alimony tied in with their Social Security payments?
It was to a certain extent, where she
doesn't
said
it make sense if she thought he was making 600 and change and she was making 300 and change, she'll give them both 450? Doesn't that appear to be what she was trying to do?
I think she stated that's what she did in terms of coming to the figures, at least. Yes.
So if he wasn't actually making 650, isn't that again, I don't mean to keep repeating my same question, but isn't that an error? And if it is, do we have to remand to ask the judge to say?
Well, unless you find that there's some other basis on which you can justify the $150. And I think that you could do so on the basis of her finding that of the unexplained, startling increases in his expenditures, that he never offered any evidence about how they got to that point. And then the discrepancies with regard to the amount that he's applying towards his debt service, even that alone would justify, taking those funds to give her a very modest $150 per week, which is not an awful lot of money.
Well, that was about half of what he was paying under the alimony order at the time of the hearing. He was paying like 301, I think.
Yes, and in fact, it had gotten down to 301 because we brought a modification action prior to that, which I think is referenced in the record, that he was paying 360 at one point. And in order for her to qualify for the PACE program, it had to be reduced at that time down to $301. And that's why he was paying that amount of money then rather than the 360 from before.
And maybe I missed this, but was there a request to reconsider based on maybe the incorrect amount determined? Do you know?
No, in terms of the case record here, no.
Yeah, did Ms. Waller file a motion to reconsider?
Not that I recall. The answer is no.
I have nothing further.
And I think I've exhausted the points that have been raised, so I have nothing further.
Mrs. Hand?
No, thanks,
No.
all set.
Okay, well, thank you both. We'll take the case under advisement. Thank you for participating by Zoom and agreeing to do so. And that concludes